Neil Gaughran, and Chief Constable of the Police Service of Northern Ireland.
Lord Clerk will explain the judgment of the court.
Mr. Fergus Gaughran, the appellant, was arrested for driving with excess alcohol on the 14th of October 2008. He pleaded guilty to that offence on the 5th of November 2008. He was fined £50 and disqualified from driving for 12 months. He is and was, at all relevant times, an adult. When he was arrested, the Police Service of Northern Ireland, PSNI for short, lawfully obtained from him his fingerprints, a photograph, and a non-intimate DNA sample from which a DNA profile was taken. A DNA profile is digitized information representing a very small part of a person's DNA. It indicates a person's gender and provides a means of identification. The profile is held on a Forensic Science Northern Ireland database. At present, the statutory position in Northern Ireland is that the PSNI may retain fingerprints, photographs, DNA samples, and DNA profiles for an indefinite period after they have fulfilled the purpose for which they were taken. But they may only be used for specified policing purposes. When the Criminal Justice Northern Ireland Act 2013 comes into force, the PSNI will be required to destroy all DNA samples as soon as a DNA profile has been taken, or within 6 months of taking of the DNA sample, which broadly brings the position into line with the current legislation in England and Wales. Since the PSNI intends to destroy the sample when that act comes into force, the appeal is concerned only with retention of the DNA profile. In a case called S and Marper against the United Kingdom, the European Court of Human Rights held that the United Kingdom's policy of indefinite retention of individuals' fingerprints, cellular samples, and DNA profiles after proceedings against them had led to an acquittal or discontinuance was a disproportionate interference with their right to respect for private life under Article 8 of the European Convention on Human Rights, the ECHR. As a result, the PSNI now only retains indefinitely biometric data of those convicted of crimes. The appellant says that the PSNI's retention of his data breaches Article 8. On the one hand, the PSNI accepts that such retention is an interference with the appellant's right to respect for his personal life under Article 8, whereas on the other hand, the appellant accepts that the interference is in accordance with law and pursues a legitimate aim under Article 8.2. The only question is, therefore, whether the interference was proportionate. The Divisional Court in Northern Ireland held that it was, but the appellant appeals to the Supreme Court, arguing that it was not. The Supreme Court dismisses the appeal by a majority of 4-1. I give the leading judgment, with which Lord Newburger, Lady Hale and Lord Sumption agree. Lord Kerr dissents. The majority concludes that in S and Marper, the European Court of Human Rights was concerned only with the position of suspected but non-convicted persons, not convicted persons. Its criticism of the United Kingdom's blanket and indiscriminate data retention policy should accordingly be read with that focus in mind. The majority recognises that the policy as it applies to convicted persons could be described as a blanket policy. However, it concludes that the policy is in fact proportionate in the light of these 6 factors. 1. In S and Marper, the European Court of Human Rights recognised the importance of the use of DNA material in the solving of crime. Moreover, the extent of the interference with the individual's Article 8 rights in question is low. Further, it is important to note that the present scheme is concerned only with the retention of the DNA profile and applies only to adults, whereas the scheme criticised by the European Court provided for the retention of the full sample and did not distinguish between children and adults. 2, factors such as the threshold of offence, whether retention is permitted once a conviction has been spent, and whether retention is permitted indefinitely or is subject to a time limit, are potentially relevant but not decisive in the proportionality analysis. 3, the potential benefit to the public of retaining the DNA profiles of those who are convicted is considerable and outweighs the interference with the right of the individual. The retention may even benefit the individual by establishing that he or she did not commit an offence. 4, in S and MARPA, the European Court placed some reliance on the fact that the United Kingdom was almost alone amongst ECHR member states in indefinitely retaining biometric data of non-convicted persons. By contrast, in the case of convicted persons, there is a much broader range of approaches amongst member states, which broadens the margin of appreciation accorded to individual states. 5, adopting a blanket measure is legitimate in some circumstances, and it was legitimate here. 6, the retention policy is therefore within the United Kingdom's margin of appreciation, and the court has to decide for itself whether the policy is proportionate. Essentially, on the basis of the factors already mentioned, and for the reasons given by the Divisional Court, the majority concludes that it is and dismisses the appeal. Lord Kerr takes a different view and would have allowed the appeal. He does so in some detail, and I would recommend that his dissent be studied. It did not, however, persuade the majority.